So an informal business entity, a partnership is a way to go. It makes the band feel secure. It makes them get the business thing out of their mind. It's something that can be done relatively inexpensively, and it makes them feel good about being a unit. These days, it's not just about making the music, it's about getting things done. They need to feel like they're doing something. Even before they come to you, they need to feel like there's some kind of structure to them, or else they can't do their artistry. I found that a lot of bands will stop recording, will stop writing until their relationships with the other band members are codified in copyrights, trademarks, and in sometimes band partnership agreements. Either way, it's a tool we have, a product we sell as attorneys is a band partnership agreement or some kind of solidifying of their relationship. When the band walks through the door, or the singular artist, usually the leader, walks through the door, I let them know in my standard engagement letter about these things, but I don't force it down their throat. For example, trademarks, we're going to get to in the next section. Trademarks is something that the band should look at if they've got a unique band name or logo. However, if they've been using it, in the United States we have what's called use trademarks, use copyright, which differs from the other countries, but we're protected under what's called the Berne Convention. If they've been using it in interstate commerce, even intrastate commerce, we have an argument of what's called first use. So that means the band can say, listen, we have proof, we came out with an album, it's got a name and logo on it, it's in the world. It's use they have to show when it was used in case there's a challenger in the future. About trademarks, understand this. To challenge or to keep ownership of a trademark, you don't have to register it in the United States. Use is enough to have it, to be the owner of it. But to actually do anything in court, you've got to actually register it first, even if you're second in time. For example, if I created a restaurant right now called McDonald's, and I go to trademark it, very unlikely that I'd even get a trademark. But if I claim that my use was prior to Ronald McDonald's, I would have to first register mine now, and they would, of course, challenge that, but I at least have to try and get a conditional registration, and then I could challenge. But it's like a ticket you need to get in the door. With bands, you can offer them the trademark service in the beginning, but that's not the... I offer them all the services, and then they can pick and choose by their financial ability what they're looking to spend money on. Trademark, not so important. Copyright is important. The Copyright Office has changed in the last, I'd say, 5 or 6 years with regard to how they let you copyright. It used to be that they'd come in, you'd use Form SR, which is for sound recording. They give you a cassette tape or a CD. You send the cassette tape CD down, and it deals with the ownership of the copyright. Now they have forms you do strictly online, Form CO, which is in here as F. Let's switch to F for a second. Flip to section F. This is for copyright registration. Anybody here copyright written anything before with one of these forms? Okay. The forms now, they make it very simple to do. Copyright registration is important because you're dealing with who's going to own the product, the song, how is it going to be owned, and it could be very well the biggest dollar event for your client in the future. This is the formula for Coca-Cola, their copyrights. This is their bread and butter. Who owns this copyright? So a lot of my work comes with local studios who have clients come in to record music. And you'll get this a lot if you advertise to your local studios and recording studios. And clients will come in, they want to do a jingle or a commercial, and the studio tech winds up doing some production work actually on their product. And he says, listen, I'm doing some work on this, and I want to know if I have any right to any ownership in the copyright because I really think it's going to do well. And it all depends on what the original relationship is. That's why you do a studio production agreement. So usually the artist coming in is doing it work made for hire. They're paying for the time, and then somebody is working on it. If there's two ways to do it, copyright ownership in the person who's copywriting it themselves in their name, or it's a work made for hire. A work made for hire is I come in with the idea, I have a song that goes like this, da, 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 and somebody will put it all together for you and write the song. If it's a work made for hire, you own it and somebody else did the work, but you paid them to do it. That relationship should be set forth in the beginning, because otherwise the guy who did the work, a musician to put it together, or who wrote all the stuff that backs up your dada, is going to say, no, I wrote this thing as soon as it gets big. So those issues need to be addressed in the beginning. The person who is the person doing the work can have their name on the copyright form as a person credited. You'll notice on the form it's either work made for hire or it's original work done for that person. This Form CO takes in